Welcome back. In this lecture and the one before it, we're taking seriously Abigail Adams' plea to her husband John Adams that we need to remember the ladies. And we're talking about the role of women's rights in particular in the Constitution and the ways in which the special commitment to women's rights is part of not merely America's written Constitution in the 14th Amendment and the 19th Amendment, but part of America's unwritten Constitution as well, because I think the 19th Amendment means more than its words read narrowly and in isolation might seem to imply. In the last lecture, I basically made a kind of a reverse enactment argument. Remember, earlier on I said we can deduce certain principles from the very process by which a constitutional provision or an amendment was enacted. We can deduce the idea of free speech from the very adoption of the Constitution and majority rule. We can deduce a broad principle of Republican government from the very process by which the 14th Amendment was adopted. Well, here, the very process by which the 19th Amendment was adopted is in some ways not self-reinforcing, but self-undermining, because as soon as the 19th Amendment is adopted, it kind of calls into question the fairness of the process that led to it, because women weren't allowed to vote everywhere on whether women could vote. That's the whole point of the 19th Amendment, is it let women vote everywhere precisely because they weren't being allowed to vote everywhere before that. And so the process that generated, a process in which in some states women could vote, but not in other states, on the 19th Amendment itself now seems a little bit problematic, because why should women have been excluded from the process once the 19th Amendment was adopted? The 19th Amendment says women should be politically equal. So you might say, well, what else might the 19th Amendment imply that's not just on the surface? Let's take the rules of marriage. You might think the 19th Amendment says nothing at all about marriage. It's about voting. Women are equal voters, Professor. What the heck does that have to do with marriage? Well, here's one thing. Traditionally, husband and wife had a unity of domicile. They had to actually reside in the same place. That's part of what marriage is about. But after the 19th Amendment, does that work? Suppose he wants to vote in District X, and she wants to vote in District Y. And the 19th Amendment says she has a right to vote, and her right to vote shouldn't be dependent on him. And so the 19th Amendment might have some very interesting implications of a woman's right to have, for example, a separate domicile. Let's take, actually, since we're talking about marriages, let's talk about the marriages in the White House itself. And how the 19th Amendment actually has revolutionized, has really transformed the nature of presidential and vice presidential politics and relations. Now, Abigail Adams, whom I've mentioned already, she's a very forceful political figure. She's not so different, you see, from Eleanor Roosevelt. But in Abigail Adams' era, she has to kind of be a little bit cautious, and she's not holding press conferences and writing op-eds the way Eleanor Roosevelt would later, because if Abigail Adams gets out too far in front, she's giving advice to John all the time, and she's a very politically savvy person. She's the wife of one president, the mother of another, John Quincy Adams, as president-to-be. But if she's out there visibly, she's going to offend some traditionalist men, and she's not going to help her husband or her son so much, because men are the only ones who voted. Now, Eleanor Roosevelt is different, because when she's out there, women are voting. And so maybe some men are offended, but she's electrifying women. So we see the emergence of a kind of a new kind of tag team, two for the price of one. Franklin goes after the moderates. Eleanor goes after the crusaders. He tells his male friends in private, well, I can't control my wife, can you? And he kind of, they laugh. But behind the scenes, he's telling her, go for it. Two for the price of one, a new kind of political ticket, so to speak. And you see that, and that's a 19th Amendment phenomenon. You see not just Franklin and Eleanor, you see that with Bill and Hillary, 2 for the price of 1, Barack and Michelle. But these new dynamics, a new role for the First Lady, this is an entailment, an implication, albeit unwritten, of the 19th Amendment and the role that women are now actually playing as equal voters. So think about the vice president. At the founding, we move very quickly to an idea of a kind of a presidential tag team. Presidents and vice presidents are sort of a ticket. But now, after the 19th Amendment, the president has another running mate, so to speak, his spouse. At the founding, John Adams and Thomas Jefferson and Alexander Hamilton, they're all keeping an eye on each other. They maybe all want to succeed Washington eventually. And so they're founding rivals. When Washington leaves the stage, they're gonna all be vying for this top position, and they're eyeing each other very suspiciously. But no one's worried about Martha Washington. She's not going to succeed George. But now, it's possible, you see, that presidents can be succeeded by their spouses, as governors have been succeeded by their spouses. And Al Gore has to think about Hillary Clinton, for example, in a way that the founders didn't have to think about Martha Washington as a possible political heir apparent. So the very dynamics of presidential succession, the role of the vice president, have been, I think, transformed by the deep, albeit unwritten, logic of the 19th Amendment. Let's talk about the two of the most famous cases decided in the 20th century involving women's rights: Griswold versus Connecticut and Roe versus Wade. In an earlier chapter, we talked about America's lived constitution, and under a kind of traditionalist approach, a Burkean approach based on custom, you could say, well, Griswold was a pretty easy case. Connecticut was the only state in the Union that actually made it a crime for married couples to use contraception in the privacy of their bedroom. That was a weird law, an outlier, eccentric, un-American, so to speak, out of sync with deep American customs and traditions, and so it could be invalidated just on that ground alone, and that's what we talked about. Roe, you see, you can't quite make that argument because laws prohibiting abortions in various contexts were quite prominent. Roe announced some sweeping rules about the abortion right that were way ahead of actual practice in the several states at the time. The rules that the Supreme Court announced in 1973 in Roe versus Wade, in fact, rendered unconstitutional the laws of, I think, 49 of the 50 states. Only New York satisfied Roe's rules. So Griswold invalidated one state law, Connecticut, which is a weird one. Griswold can be defended on traditionalist grounds. Roe, not so much. Hard to defend on traditionalist grounds because it's striking down all sorts of laws that have deep roots, that have tradition on their behalf. That doesn't mean Roe is necessarily wrong. We'd want to think about this unwritten constitution of American feminism. We have to remember the ladies. So here's a different way of thinking about both Griswold and Roe. I think it would be outlandish to think that the 19th Amendment requires us to disregard all laws that were passed before women voted. The 19th Amendment doesn't basically say repudiate the entire legal experience before women got the vote. It purports to be an amendment to an existing ongoing system. But there are a certain kind of law that maybe are problematic because of the logic of the 19th Amendment. A certain kind of law that was passed before women got the vote that imposed particular disabilities on women as women, disabilities of childbearing and, as a practical matter, child rearing, disabilities that might have made it more difficult for women to be equal legislators and judges and lawyers and political participants. And so it's possible to imagine a set of laws that were adopted before women had the vote that might be self-entrenching in certain ways, might make it actually difficult for women to repeal even after women got the vote. arguably, the laws in both Griswold and Roe were of this sort. Here's a key fact about Griswold that we haven't talked about before. The law in Griswold was adopted by Connecticut initially at a time when no woman could vote in Connecticut. It was adopted long before women's suffrage. And so, too, actually, the law in Texas that was at issue in Roe versus Wade. So these laws, as a practical matter, are having women and only women bear children, because only women bear children. If you prohibit contraception or you prohibit abortion, you're going to have more unwanted pregnancies carried to term, perhaps. And so now women are having babies that they might have preferred not to have, and then taking care of them typically, at least in infancy. And so instead of being in the House, as in the House of Representatives, they're in the home. That is, their private dwelling places taking care of kids. So there are fewer women in the House and the Senate. Because women are in the home, there are fewer women in the House and the Senate and cabinet positions and the judiciary and law firms. Now, this is not an airtight argument in a variety of ways, but one argument might be for certain laws that were passed before women had the vote and that imposed certain special disabilities on women that might make it difficult actually for women themselves to strike these laws off the books, to get them repealed. Here's maybe what we should do. We should wipe the slate clean, not of all laws passed before women have the suffrage, but only of these laws targeted at women and entrenching, possibly in entrenching their anti-woman effect. Those laws should be wiped off the books after women get the vote. And if they're repassed in a process in which women are equal participants, well, that would be very different. But we shouldn't merely perpetuate these old laws that impose special disabilities on women as women and that women themselves didn't initially vote for. That's a kind of modest middle position. It's hardly airtight because you can say, well, these laws don't discriminate against women. They're about contraception and abortion. And not all women, for example, engage in procreative sex, and not all women are pregnant. Yes, but only women are going to actually be bearing the children here. And so whether it's formally sex-based or not, isn't it, as a practical matter, just because it's targeting only a subset of women, isn't that on account of sex within the relevant meaning of let's say, the 19th Amendment? Let's imagine a law that said, we allow women to vote, not pregnant women, however, because pregnancy just discombobulates them. So this is not a violation of the 19th Amendment. We're letting women vote, just not pregnant women. If you think that would be unconstitutional as a violation of the 19th Amendment idea, you're saying laws that target pregnancy as such are laws on account of sex. Within the meaning of the 19th Amendment. And now the only question is whether other laws that target pregnancy as such and that impose disabilities on pregnant persons as such might be threatening to the deep idea of women's equality at the heart of the 14th and 19th Amendment. If, as a practical matter, these laws are going to be more difficult, are going to impose disabilities on women as women and be difficult for women to undo, to repeal, even after they've formally got the vote, because these laws are kind of keeping them at home rather than as full and equal political participants. I do not mean to suggest that we've just come up with a knockdown argument in support of Roe versus Wade. Roe versus Wade is a very complicated issue. There's the issue of unborn innocent human life on the other side. What I do mean to suggest is that in addition to arguments of custom and tradition that we've talked about before, we have to think about arguments of women's equality as central. And one very interesting fact to pay attention to is when certain laws that limit women's options and opportunities, when those laws were adopted. If they were adopted before women's suffrage, might these laws be particularly suspect and vulnerable precisely because the 19th Amendment calls into question, to some extent, the fairness of what went before. That's the deep, albeit unwritten, thought. So I'll give you one other example, and then we'll wrap up. As is the tradition in this lecture series, I want to focus you on the picture that animates the relevant chapter of the book. This is a chapter called Remembering the Ladies, America's Feminist Constitution. Just to remind you, it's chapter 7 of the book. Here's the book, America's Unwritten Constitution, that we're going through. This is a cartoon in the 19-teens. It's a cartoon, actually, a political cartoon that appears actually in 1915, right when America is in the middle of this conversation, of course, about women's suffrage, the 19-teens, the progressive era. And it shows, obviously, a very emotional, all-male jury rendering the verdict of not guilty. Apparently, there's a woman defendant who is not guilty. Maybe she's done something to her husband in self-defense or something. She's being hugged, apparently, by her lawyer who has a handkerchief, and he's been playing to the jury's emotions. And so they've rendered the verdict not guilty. And here's the caption, quote, "Women are too sentimental for jury duty," unquote. Who's that attributed to, that idea that women are too sentimental for jury duty? That's an anti-suffrage argument. This cartoon has embedded within it a deep constitutional theory. One is it says, well, you know, men can be sentimental too. Why are we singling out women? So there's an egalitarian thought here. But when they say anti-suffrage argument, here's what they're saying. When women vote, that's going to entail, that's going to mean that women are going to be on juries as well. Even though the 19th Amendment may not say, the women's suffrage amendments that are being passed in state constitution after state constitution might not explicitly say women have a right to serve equally on juries. That is the logical entailment of women suffrage. Women have a right to vote. And if they have a right to vote for ordinary elections, why don't they have a right to serve on juries? Textually, we can say, why don't they have a right to vote on juries and in jury and jury boxes and in legislative assemblies? So the deep logic here of this political cartoon is that the 19th Amendment, that the women's suffrage revolution is not just about voting narrowly understood. It's about women's full and equal participation in all sorts of realms of government. In the jury box, I would say in the legislature. Where does it say that women have a right to run for president? It doesn't explicitly in the written Constitution. And the written Constitution in Article 2 says he, him, his when it refers to the Constitution. At the founding, they're wondering whether presidents are going to be kings or like kings. They're never asking whether presidents are going to be like queens. And at the founding, if some state, say Connecticut, had passed a law saying, we're going to let presidential candidates' names appear on the ballot, but only male presidential candidates, it's hard to imagine that's an unconstitutional law at the founding, because that's actually those were the rules in virtually all the states, that only men voted and could be voted for. But today, is it imaginable that a state could say, women candidates for president, say Hillary Clinton, Michelle Bachmann, Sarah Palin, take your pick. Is it imaginable that a state could say women candidates' names can't appear on the ballot? I think it's not imaginable. But if you ask, that is unconstitutional, a law like that. But where does the written Constitution say so in so many words? It doesn't. And if we are to find the deep root of this principle that women have a right not just to vote, but to be voted for, right to run for president, right to be president, to serve as president, I think it's an unwritten implication of the 19th Amendment. It's just connected to this cartoon. If women are fit to vote, they are fit to serve in juries, they're fit to serve in the legislature, they're fit to run for office, they're fit to be president, and cabinet officers and judges. They are equal political participants. That's the deep logic of this political cartoon, that this suffrage movement has deeper and broader entailments and implications. And actually, here's a reading suggestion for you if you're interested in this. One of the most famous short stories of this era is a short story by a woman named Susan Glaspell. It's entitled A Jury of Her Peers. It becomes a Broadway play called Trifles. I don't want to ruin it too much, but just in a nutshell, it's about how the men end up missing all sorts of things, and women notice things that we men sometimes just sort of miss, important things. And it's called A Jury of Her Peers, and in its context, of course, it's all about women's suffrage. You know, it's understanding deep connections between the debate about whether women should be voters and debates about whether they should also be jurors. And in many of the states, actually, as soon as women become voters, state Supreme Courts say, oh, well, that means they have to be equal jurors, too. They have a right to vote equally on juries. The U.S. Supreme Court eventually says women have a right to serve equally on juries, but unfortunately, it does that many years after the 19th Amendment and doesn't rely on the 19th Amendment as it should have, because this is a deep logical implication of the 19th Amendment that women are political equals in all sorts of domains of life. Let me finally just come back to the letter that Abigail Adams wrote to John Adams. This is in the spring of 1776. Here's what she writes in a private letter to her husband John. I long to hear that you have declared an independency, meaning you've declared independence. And by the way, in the new code of laws, which I suppose it will be necessary for you to make, I desire you would remember the ladies and be more generous and favorable to them than your ancestors. Do not put such unlimited power in the hands of the husbands. Remember, all men would be tyrants if they could. If particular care and attention is not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound to any laws in which we have no voice or representation. So 1776, even before the Declaration of Independence and before the Constitution, Abigail Adams is saying, you know, gee, this no taxation without representation, this consent of the governed, why are we being bound by laws in which we have no proper voice or representation? And at the founding, the idea is actually, well, your husbands really do virtually represent you. But my friends, that was the very logic, that women are virtually represented by their husbands, their brothers, their fathers, their sons. That's the very logic that's repudiated by the 19th Amendment itself. It says, no, women actually get to represent themselves. They don't have to count on the men to vote for them. And so the deep idea that I want you to take seriously is that the 19th Amendment suggests that we need to pay attention to Abigail Adams, to remember the ladies. Because John Adams didn't quite pay attention, and the women did foment a rebellion. First, in the 14th Amendment, they got that idea of birth equality in the Constitution, and women were there alongside men, people like Elizabeth Cady Stanton, alongside the John Binghams of the world, the Grimke sisters and others. So the first thing they got was a 14th Amendment, whose Section 1 said that everyone's equal, at birth, black and white, male and female, Jew and Gentile. And then a second revolution, a 19th Amendment, in which they put in the idea of political equality. And then actually a third revolution, unwritten, later in the 20th century, in which feminists basically took these ideas of women's equality and broadened and deepened them and said, you know, we have to be equal in all sorts of domains of life. And in that era, the Supreme Court, in effect, read the 14th Amendment and the 19th Amendment together to be, in effect, the equivalent of what the Equal Rights Amendment, never adopted, proposed but never adopted, would have meant. Today, our courts pretty much act, I think, similarly to how they would if the ERA had, in fact, been ratified. So, Abigail, we do remember you. Abigail, you were the preeminent founding mother and wife. And in our next couple of lectures, we're going to move from that preeminent founding mother, Abigail Adams, and consider the founding father who towers head and shoulders above everyone else in his generation. Of course, we're going to talk about George Washington, so stay tuned.